Right, to expand on this, we're joined now by legal expert Nthabiseng Dubazana. Very good afternoon to you. The curious case of the second docket, I suppose this throws the entire case into disarray.
Yes, it does. We see ourselves dealing with a very interesting issue, not really unprecedented, but very not following procedure, basically, because now we're being introduced to the second docket as if it is evidence that is to support the current case before the court, which does not make sense. Because if you're going to introduce an entire case docket, it means that those people is the state versus, which means they are accused persons themselves. They should not be added as witnesses to this current trial that we're busy with. They should actually be added as accused persons. But now, this joint or what we call consolidation of cases is happening at the wrong time. This should have happened prior to the trial commencing. I mean, how long has it been that, for example, Advocate Defo has been mentioned that there's an existence of this docket? Even months before this trial started, he went out on air and talked about this docket, that there were two different dockets pertaining to the same matter. This should have been the opportune time for the state to make sure that these dockets prior to the trial starting are consolidated and then the accused persons appear in their entirety and not do what is currently happening before the court now.
The other matter is that of delays. I mean, we heard Judge Chifewa Maumela saying that, you know, a family has already lost a son and there's been a lot of time wasted and that it cannot be one that continues to be on hold.
Yeah.
I mean, what do you imagine to be the outcome of the deliberations that will take place tomorrow? We understand they'll be sitting to chart a way forward. What will some of the elements of that conversation have to embody?
So the one thing that they need to now decide upon is the time aspect, because in High Court, unlike in match courts, in lower courts rather, a trial can be postponed, you know, in various times, whereas in the High Court, time is actually quite limited. So time was allocated for this matter to be heard between this date and that date. But throwing this new docket into the picture now changes this aspect, because now the defense attorney, especially Advocate Mshololo, hasn't had the opportunity to prepare with her client, have consultations, prepare any evidence pertaining to that, see if there's any witnesses that are going to come and answer to whatever allegations that are going to be set forth in this docket. So the time aspect now has to be determined. And mind you, once the time has been allocated to a certain case, the court also has dates for other cases. It means we're looking at some time towards the end of the year for this case to resume, should this thing actually be an issue. That's the first thing. And then the second thing now we have to deal with the author of the document that Advocate Mshololo just read into record right now, whether or not these accused persons are actually going to be charged and they're actually going to be accused. If they are going to be so, then it means that this case that we're currently dealing with may be deemed to start de novo, which means it has to start from scratch, because these accused persons weren't present in court to hear the evidence of at least the one witness that is currently being cross-examined. But it means they have missed a huge chunk of information. Their attorneys have missed a huge chunk of information, which they would have used when they are doing their own cross-examination after having heard the evidence in chief of this specific witness. And then there's the issue of whether this docket is the prima facie case in that docket for them to actually proceed with it, because they cannot now use these accused persons in the 375 docket as witnesses in this matter. It doesn't work that way. So the NDPP has to really make a decision on how it's going to proceed with these two dockets, which will then determine if the case is started de novo, which will then determine the issue of time.
Sure. Some really interesting revelations there. I suppose this weakens the state's case against the 5 accused men at this point.
Already, with just the evidence of the way cross-examination is going, already the ballistic and forensic issues was already weakening the state's case. So now with this happening and being thrown into the works, as a presiding officer, you're starting to think, but why am I sitting with 5 accused persons here, when in actual fact there's like 7 others? I should be sitting here with like 12 or 10 accused people. What is going on? So it's already casting doubt in the mind of the presiding officer, which means by the end of the state's case, most likely if the defense were to apply for a Section 174, for example, which is basically an application for discharge, without the accused persons ever having uttered a single word, they could possibly succeed. So it's not going to help the family get answers as quick as they would have loved to get them. They've been waiting so long already, and now these things are happening which may delay it even further. So we're looking at a very interesting time come tomorrow to see what's going to happen.
Yeah, this is a matter of public interest. Yes. I mean, South Africans are looking for answers. 8 years is a very long time. And is it possible that we could see a case where the second docket, in whatever legal jargon and technicalities, that that second docket could be done away with without those people listed now appearing in court? Or because it's in the public eye, the names have been read out several times in court, is this now automatic that these suspects will appear in court?
Well, nothing right now is automatic. But by virtue of that, because that's an indictment document that was read by Advocate Msholo, it seems it wasn't particularly signed, rather, by the author, which means without a signature, they couldn't exactly charge the accused persons. So, in my opinion, there is a prima facie case against the accused, which means the state believes they could secure a conviction at the end of the trial. I don't foresee it going away, per se, but something has to be done about it. Currently, it has been presented as evidence in a part-heard matter. So you really can't do away with it. But then now you have to answer questions that are coming from the defense attorneys of all these things that Advocate Msholo wants clarification on. And therefore, it's opened Pandora's box or a can of worms if you have that. And then it has to be answered at the end of the day. Something has to happen. As to what will happen, because it's kind of strange in terms of criminal procedure, we're not sure right now. We just have to see what the state is going to do tomorrow.
Advocate Msholo was adamant. I mean, she stood her ground in court when she was asked, to maybe now continue her cross-examination of Sergeant Thabo Mosia. We heard Advocate Baloyi saying that this must happen because Sergeant Mosia needs to go to hospital. He's got a medical condition that needs to be attended to. But she stood her ground, saying that she needs time and no one can establish how much time she will need. What will she be doing with that time?
Rightfully so. She has to go speak to her clients. Unfortunately, her clients are in custody, so which means that she has to allocate time to go to prison and have an actual consultation with her clients with the new information that she now has. So being told that, okay, we're giving you a day, 2 weeks, or whatever, it's not justice to me, because I don't know what I'm going to be met with when I consult with my client, what kind of evidence is going to come from my consultation. Just now, I have to now find 2 or 3 other witnesses that are going to corroborate my client's version, and I have to interview them. So I cannot be told, as defense attorney, how much time I need to prepare for my client. Even prior to trial starting, when the disclosure is now done, it gets postponed for consultation, which sometimes is a month, whereby you're given an opportunity to prepare based on the documents that you have. And then thereafter, give pre-trial, and then we go on until now. So this situation, I would have done the same thing. Don't ask me to cross-examine when you just threw a bomb in my way that I now have to deal with.
I'd like us to also touch on a different matter and perhaps take our viewers to a soundbite that speaks to the language part of court proceedings. A lot of questions have been asked around that, and conversations have also expanded around that. We heard forensic expert Dr. Zakira Dokrat say that the murder trial of Senzo Meyiwa has cast a spotlight on the use of the English language during court proceedings. Observers have raised concern about what they call a one-size-fits-all approach to the use of language in a multilingual country such as South Africa. In recent events, a judicial officer as well as a state witness experienced linguistic challenges when they were seen to be struggling with the language in court. Let's listen to this.
I think, this Meyiwa trial has really shone the spotlight, as you said in the beginning, from a point of perspective of the language of record being English only, from a point of the interpretation happening, police, as well as legal practitioners and their linguistic capabilities as well. And the English language of record policy that we currently have, which is English only, restricts us in terms of that it places sole reliance on interpretation in our courts. And we know in the South African context that is very problematic.
Right, in continuing with our conversation, we, of course, have been very judgmental, human nature, as Advocate Malisela Defo seemed to perhaps be lost for words in English. And also now casting a spotlight on the use of English in the courts, and what then it implies when a legal expert is at a loss of explanation because of the use of English. I mean, it's not a measure of intelligence.
No, it really isn't. And listen, the issue of language has been an ongoing debate. But if you go to lower courts, actually, you would find sometimes that the presiding officer speaks isiZulu. And then the accused person who's appearing in front of them, especially during first appearances, they actually interact in the language. And then because it's not recorded most of the time, well, it is recorded, but in the sense of the way that we are dealing with this case, then he just records in English in terms of what he's writing on his record. So the issue of language, especially in lower courts, is not as hectic as it is in upper courts. But it is an issue nonetheless. And sometimes the interpreters that we have in court sometimes don't interpret correctly what it is that we are asking to the witnesses in the box. I mean, myself, I remember there was a time I had to go back to my home language because the person I was cross-examining was speaking my home language, and the interpreter was not putting across because she didn't speak Sesotho. So I ended up saying, Your Worship, if you will allow me, let me speak with the witness in Sesotho, and then I will relay to the court, because the presiding officer was not was of Indian descent. So I had to then interpret my cross-examination in that manner. So the issue of language has to be looked at, because at the end of the day, the people that do appear in our courts sometimes cannot understand the interpretation, and sometimes interpretation, when it comes back from the witness, doesn't come correctly, even though I heard what was correctly said, but then when it comes back into English, it is not correctly put. So it is quite an issue indeed.
Absolutely. Thank you so much for your time. Thanks for coming to speak to us in studio. Legal expert Nthabiseng Dubazana there.